Good evening, everybody, and welcome to the grand finals for the 2022 Dominion Varsity Cup. My name is John Wu, and tonight I have the honor of being your host for this evening. Over the last couple of days, we have seen some truly spectacular bouts of advocacy as students competed over the course of 4 rounds. And tonight we have the great pleasure of watching the 2 top teams from across Canada face off in what is sure to be a heck of a show. So as a bit of a quick background, Dominion Mock Trial is a nonprofit organization dedicated to improving access to legal education and building the mock trial and mooting community across our fine nation. And tonight is a true celebration of legal advocacy in that we have some very, very special people joining us, along with some amazing students who have worked long and hard in order to make it to this stage. So to kick things off, I will be doing a brief introduction of our judges before we introduce our teams, and finally moving into the submissions themselves. So joining us on our esteemed panel this fine evening, first of all, we have the Honorable Jeff Adams. So Jeff is an associate at Fasken Martineau, one of Canada's top full-service firms, where he practices litigation, particularly in the labor and employment space. Justice Adams is an experienced entrepreneur who has taught me quite a lot about what it means to run a business. And prior to that, he enjoyed quite an illustrious career as a competitive athlete, where he represented Canada on the global stage. Thank you for joining us tonight, Justice Adams.
Thank you.
Next, we have someone who is very near and dear to my heart, the Honorable Justice Jennifer Davidson. Jennifer is an associate at Dietz Williams Wall, a firm that specializes in intellectual property and technology issues. There, Jennifer litigates on a number of different issues, mostly with regards to high growth tech companies. And she is incredibly involved, both on the private practice side, as well as in terms of community service, where she serves as an executive on CanTech, the Canadian Association for Technology Lawyers, along with coaching Osgood's very own mooting teams. Welcome, Jennifer.
Thank you, John.
Next up, we have Justice Omar Ha-Redeye. So Omar is an incredibly accomplished attorney and academic, where he runs his own legal practice at Fleet Street Law, where he specializes in civil litigation, working primarily with companies in the energy space, amongst many other types of diverse clientele. He is also quite an accomplished academic, having taught for years at the Ted Rogers School of Management and recently at Lincoln Alexander Law School, Canada's newest law school. Omar is a true passionate supporter of youth education, having volunteered at quite a few of Dominion's events, for which we recognized him a little bit earlier during this competition. And we're really honored to have him back for the finals. Welcome, Omar.
It's my pleasure. Thank you for having me.
And next up, we have a real treat, the Honorable Justice David M. Brown. So Justice Brown was appointed to the Court of Appeal for Ontario in 2014 after serving an extensive term on the Superior Court of Justice. Justice Brown was formerly a partner with Stikeman Elliott, where he also focused on litigation in the energy sector, and has also been involved in the academic side as an adjunct professor at Osgood Hall Law School. Justice Brown is a huge supporter of the mooting community here in the country and is regularly engaged with many students. He's someone who is truly passionate about improving and advancing the legal education and the profession. And we're really excited to have him here to work with our students tonight. Welcome, Justice Brown.
Thanks for having me.
And last, but certainly not least, we have the Honorable Justice Marshall Rothstein. Justice Rothstein served on the Supreme Court of Canada for many years, where he specialized in dealing with highly complex issues, involving both tax and litigation, amongst all the other myriad of issues which appear before the Supreme Court. He is highly involved in the mooting scene, regularly coming in to coach students at various law schools, and currently serves as counsel at Osler's, where he helps to advise both lawyers and clients on complex issues. Welcome, Justice Rothstein.
Thank you. Good to be here.
So without any further ado, I think that wraps up our introduction to the justices. So thanks again, Justice Adams, Davidson, Ha-Redeye, Brown, and Rothstein. And with that, we can bring on the show. So tonight we have two teams from across Canada that fought long and hard in order to make it to this point. In the red corner, representing the appellant, the lawyer bent, we have, and if you would like to introduce yourselves. Jacob, Ellen.
Yes, Your Honor. My name is Jacob Muller, and I will be making my submissions along with my co-counsel, Helen Lee.
And on the blue side, representing the respondent, Platnick, we have.
We for the respondents, me, Beldress, and my co-counsel Jeffries, who will be starting, or for the respondent side.
Excellent. So tonight we're about to see a truly fantastic case, one that engages the law and society on multiple different fronts when it comes to defamation, when it comes to free speech, when it comes to professional responsibility. It is truly a thrilling case, and we hope that all of you that out there who are spectating this will enjoy the show. So without any further ado, we will get this round started. Each speaker will have a total of 10 minutes with which to make their submissions. So set your timers. And Tony, if you have your clock set. Tony?
Yep, John, we're good to go.
We're good to go? Excellent. So then in that case, I will turn it over to the presiding judge for this evening, Justice Rothstein, to kick off the proceedings.
Thank you very much. We'll proceed. Mr. Muller, do you proceed first, or Miss Lee?
Your Honor, I will be going first.
Okay, Miss Lee, proceed.
Thank you, Your Honor. Good evening, Justice. Please, my today representing the in subsection 4A2. So as the Supreme Court has said in points protection, here the plaintiff has to satisfy the judges that there are grounds to believe there are no valid defenses that has a prospect of success. Emphasis on the word no. And so Ms. Bent's defense of qualified privilege in this case is clearly a valid defense, because with qualified privilege, there must be a duty on the sender to send out the communication and a reciprocal duty on the recipient's side to receive that communication. So the circumstances here in which Ms. Bent makes her communication is crucial. And as you know, at the time she published her email, she was the president-elect of the Ontario Trial Lawyer Association. In that role, and as an advocate on behalf of victims of motor vehicle accidents, she has a clear social, legal, and moral duty to express concerns about, quote, selective and misleading expert reports in an insurance industry that's already under very public scrutiny. And as a lawyer,
Qualified privilege, does she have any obligations Does she have a due diligence obligation?
Well, Justice Rothstein, yes, there is a certain level of due diligence that's expected, but we would submit that in this case, she had a reasonable belief in what she is saying, in the statements she's issuing about Dr. Platnick. And that is something that we will be going over in extensive detail as it relates to the recklessness standard in the malice point. So for now, I would just like to say that yes, but we would submit that she has met the standard that she needs to meet in order for the defense of qualified privilege to apply. And so as a lawyer, it's also her duty to improve the administration of justice as a whole. So now on the reciprocal side, in terms of the recipients of her email, she sent the email to a limited constituency of OTLA attorneys, all of which are bound under a confidentiality clause, who all have an interest and duty in receiving her warning about potential misconduct in the insurance industry.
But counsel, isn't this duty, if such a duty exists, also have to be exerted in a manner that is reasonably appropriate in the manner in which it's discharged?
Yes, and that is the point I will be addressing now, Justice Ha-Redeye. So this is a concern that falls under the point our friend may raise on exceeding qualified privilege. And so we would submit that in this instance, Hill sets out the standard that the statements made here have to be, as you say, reasonably appropriate to fall under qualified privilege. But the key here is that it only has to be relevant to her discharge of duty. And we submit here that her discharge of duty is to warn her colleagues about potential selective and misleading expert reports. And the standard of relevance here is key because with respect to the majority and the Supreme Court, we submit that they erred in applying a standard of necessity instead. And they say that it wasn't necessary for Ms. Fent to identify Dr. Platnick, therefore she exceeded the scope of her qualified privilege. But we would submit that if we use the standard of necessity, we run the risk of making the statements protected under qualified privilege too limited. And that would have dangerous implications for professionals aiming to speak out on important issues related to public interest. And I'll expand on that point by saying that if we apply the standard of necessity, we're moving away from the intent of having qualified privilege in the first place. So for an expression to be defamatory, the plaintiff clearly needs to be identifiable. That's something Grant sets out. So if the respondent here was not even mentioned by name, then there would be no lawsuit, meaning there would be no need to raise the defense of qualified privilege in the first place. So from that, we can infer that qualified privilege exists to protect speech made in the public interest, recognizing that yes, there may be a potential harm to some people, but that the benefits of that the public receives is much greater. And so applying the standard of relevance here, it comes back to what is Ms. Fent's duty that she is trying to discharge, and that is to warn her colleagues about potential misconduct in the insurance industry as they relate to expert doctors. And she reasonably believed that the defendant, Howard Platnick, is an expert who has engaged in exactly this type of misconduct. And she's warning her colleagues about this type of misconduct. So there should be no argument that her using Dr. Platnick as an example is relevant to the underlying message of her email.
But couldn't she have made the point without naming him? I mean, if her concern is misconduct in the insurance industry, couldn't she have spoken about changing reports and things like that without naming the individual in a potentially defamatory way?
Well, Justice Rothstein, yes, she could have, but it would not have had the same impact as if she mentioned Dr. Platnick by name. And the key here is that there is evidence of Dr. Platnick's misconduct. So by referencing a specific doctor who has engaged in the type of misconduct that she's warning them about, yes, it could become potentially defamatory, but we have to consider that there is evidence of Dr. Platnick's misconduct. So any harm that he suffers from it is partially his own fault. So I'll now move on to the points our friends may.
Counsel, you mentioned that this might be this might be his own fault, but what about her own fault? Counsel had a very good understanding of what defamation is as a lawyer, I imagine, and also what proper channels might be and might not be. So should we not, if we're talking about fault, should we not be talking about both sides?
Yes, but yes, Justice Davidson. But in this case, legally speaking, the statements she made regarding Dr. Plotnick were indeed relevant to the main message of her email, and that we submit that that should be enough to satisfy that she did not exceed the scope of her qualified privilege. And on the other point about her exceeding the scope of her communication and possibly being reckless in naming him, she had a reasonable belief that he did engage in misconduct. In the Carpenter matter, there was clear evidentiary support, witness testimony that all showed that Dr. Plotnick misrepresented a consensus to benefit his employer, the insurance company, at the price of a victim of motor vehicle accidents. And in the Dua matter, she drew her conclusion on that case based on the evidence she had in Carpenter. And if there was indeed no evidence of misconduct on Dr. Plotnick's part in Carpenter, she wouldn't have been able to draw her conclusion on Dua in the first place. So we submit that because of that, she did have a reasonable belief in the truth of her statements. And since she did believe in the truth of her statements, it wouldn't technically be defamatory. Now, we know now that—
Well, with respect, that's not the test. The defamatory impact flow, or the nature of the comments is defamatory, flows from the content of the comments, which destroyed the guy's career. I mean, you're talking about the most severe comments. They were highly defamatory. So you're stuck with defamatory comments. You got to craft a reasonable defense on qualified privilege. So I don't think the link that you make is accurate.
Well, Justice Brown, with respect, yes, but at the time, she did not know that what she was saying was false. She drew a reasonable conclusion, and that was how she was able to come to her conclusion about Dua. And another point I guess I would like to make on the Dua matter was that she didn't have any reason to suspect that there was anything to have gone on between Dr. Dua and Dr. Plotnick because the insurance company did not provide her with that information. And had they provided her with information of how Dr. Plotnick, in fact, did not do anything wrong, then she would not have sent out the statement saying that Dr. Plotnick did something wrong with regards to the Dua matter. And the thing is, it should be the responsibility of the insurance company.
Well, why do you say that, counsel? Did she call Dr. Plotnick and ask for his comment? He's the one whose reputation was the target here, not the insurance company.
Of course, but with respect, Dr. Plotnick was working for the insurance company, and the insurance company was the one who should have been responsible for providing his reports to Ms. Benn. And with regards to Dr. Plotnick, he should have clarified in his report that that he based his report off a second version of Dr. Dua's report. And he could have done a much better job of clarifying what exactly occurred to make sure that Ms. Benn would not be confused as to the events that happened. And that's kind of a point our friends may raise on malice, is the plaintiff has the burden of proving that the defendant acted with knowing or reckless disregard for the truth. And that's a really high burden. And as we've discussed before, the primary concern here is with potential recklessness in the Dua matter, but the respondents have to prove that she moved beyond simply being negligent or careless, and she had a purposeful disregard for the truth. And this is clearly not the case because she did have a reasonable belief that there was evidence of his misconduct in the Dua matter. So because of that reason, she sent out her email, and later it was uncovered that in fact he did not do anything wrong in the Dua matter. But because of the strong evidence she had in Carpenter, the conclusion she came to Dua could be seen as reasonable.
But she needed to be able to defend both. Carpenter wasn't enough.
Pardon? Sorry, Justice Rothstein, could you please repeat your question?
I'm saying for her to succeed in the motion, she has to demonstrate that there's no valid defense. Sorry, she has to be able to contend with both Carpenter and Dua. In Carpenter, she may have had a valid claim. In Dua, it seems to be much more doubtful.
Yes, and that is where the dissent in the Supreme Court repeatedly emphasized that she had the reasonable belief, and at the time that she sent out her email, this reasonable belief was enough to make this fact relevant. And the underlying truth of the fact is there is evidence of Dr. Platnick's misconduct that led to people suffering as a result. And this is especially strong in the Carpenter matter, but regardless of whether we consider Dua or not, Dr. Platnick did do something wrong, and that resulted in people being harmed as a result. And so that is something that
Well, but Ms. Lee, just a minute. We're not at the trial stage here. We're simply at the stage of a motion. So we don't know for sure whether she's right or whether Dr. Platnick was wrong. Aren't you taking a bit of a liberty there?
Well, yes, but Section 4B of the test specifically looks more at the balancing between the harm suffered by Dr. Platnick potentially as a result of her claims versus the public interest in her claims being made. And so we would submit that because there is evidence of Dr. Platnick's misconduct, the underlying theme behind her message was true, then the public interest in that is great. And because there is evidence of Dr. Platnick's misconduct, the public has a right to know that there is a doctor who is potentially misrepresenting their reports at the cost of the general public. And so with that, I'll conclude my submissions regarding Section 4A on qualified privilege. And I'll pass off the baton to my co-counsel. So if there are no other questions from your honor, I'll now turn to my co-counsel, Jacob. Thank you.
Mr. Muller.
Thank you, Your Honor. Justices of the court, my name is Jacob Muller, and I will be continuing the submissions begun by my co-counsel, Helen Lee. Today, I will be submitting that the appellant, Maya Bent, was not responsible for the republication of her expression, and furthermore, that the respondent will be unable to prove that the public interest of their proceeding outweighs the public interest of Ms. Bent's expression. I'll begin with addressing the notion that Ms. Bent caused the republication and thus was responsible for the harm incurred by the respondent. My friend opposing counsel will submit that the leak, which resulted in the republication, was a result of recklessness on Ms. Bent's part. The leak from the listserv server resulted in Dr. Platnick's damages, but we submit that Ms. Bent was not responsible for this leak. We must look at this from the perspective of reasonable foreseeability. Ms. Bent made her expression to a protected server of lawyers, professionals who are more familiar and arguably more bound to a confidentiality agreement than the average person. A lawyer.
How many?
Pardon me?
How many lawyers did she communicate with?
670 lawyers, Your Honor.
And you're telling us that it's reasonable to assume that not even one of those 670 lawyers might disclose this email, which is quite salacious.
Well, if we look at this, if we try to understand this because of the size of the server, we actually have to look at it from an individual lens. By assuming that the high amount of people will increase the probability of a leak, it undermines the strength of a confidentiality agreement. Each person individually enlists to the undertaking, and each person is bound to that agreement. A violation of the agreement is misconduct, which can't be foreseeable because we're in a professional field. Our clients sent the email in good faith to alert other attorneys about a matter of importance to their specific branch of legal practice, and it's a niche audience. The fact that another lawyer decided to break their legally binding undertaking, regardless of how many there were, does not make Ms. Bent liable for the leak and republication. Additionally, my friend may submit that Ms. Bent's expression caused damages before the republication, as Dr. Platnick had been blacklisted before anything had been republished. And respectfully, we contest this because the blacklisting was also a result of the leak from the server. The insurance companies could not have blacklisted Dr. Platnick without knowledge of his misconduct, knowledge that only the lawyers in the server had. And finally, we anticipate a submission from our friend that because Ms. Bent violated the defamation clause of the agreement, that the confidentiality aspect should therefore not apply. However, as I said earlier, the undertakings taken by Ms. Bent and other attorneys need to be kept individual. Just because one person potentially broke a rule doesn't mean it suddenly does not apply to everyone. That would defeat.
Also, don't the terms around this confidentiality clause also have a prohibition against defamatory conduct or defamatory statements? So if there is something that's defamatory stated on the listserv, these clauses arguably wouldn't apply. Isn't that correct?
Yes, Your Honor. But as my co-counsel had previously mentioned, the appellant Ms. Bent had a reasonable belief that what her statement was had truth, and she did not know that her statement was potentially defamatory. And I'll also add that just because Ms. Bent sent out a potentially defamatory email and she did not have knowledge of this, it doesn't mean that other attorneys are suddenly discharged from their legal obligation. I'll also add that Ms. Bent reasonably believed in the truth of her statements, and the other attorneys who conducted the leak knowingly violated the confidentiality clause. I'll now move on to my second argument regarding the weighing of public interest. The weighing exercise requires one consideration to outweigh another. And in this case, we submit that the public impact of infringing on Ms. Bent's freedom of expression is too great to allow the respondent's proceeding to continue. We need to look at the quality of the expression and the motivation behind it. Ms. Bent's expression has extremely relevant connotations for future legal and political decision-making. In this case, we're dealing with the insurance industry, a behemoth in our society, $71 billion in annual revenue. If the insurance industry were to be a country—
Counsel, before you get too far into your jury address, the plaintiff in this case is an individual who suffered great harm in his practice. Don't understand where the insurance company comes into this. We're talking about a claim in defamation for damage to a personal reputation.
That's correct, Your Honor. The connection that I'm drawing here is with the weighing exercise of public interest. Because Dr. Platnick was hired by these insurance companies and his services were used for, you could argue, their own benefit, their own business, that the public interest here is any misconduct on the part of Dr. Platnick, which correlates with the insurance industry, would then relate to the public interest, because there are people in society that are part of motor vehicle accidents and therefore become clients and therefore will suffer harm if there is misconduct. And I'll continue by saying that this is a private industry. The only control comes from government legislation. Ms. Bent's finding of misconduct on the part of experts working for the industry and her expression that serves as an aid to the administration of justice is a crucial step in future policymaking. And this brings me to—
I remember the record. I was on the appeal. I don't remember any evidence going to the nature of the industry. Well, where is this coming from?
Could you repeat, like, what aspect of the nature of the industry? Did you mean my point about the revenue?
The mechanics of the insurance industry and how they do big bad stuff and all of that sort of stuff. Where's that in the evidentiary record?
I wasn't, Your Honor, I was not making any allegations to the conduct of the insurance industry, only the specific evidence that we had from the Carpenter incident. And I believe that it can be reasonably extracted from our public knowledge that the insurance industry is a private industry. And
the judicial notice. Okay, that's fine.
Okay, thank you, Your Honor. I'll continue with saying that the motivation behind her expression must be interpreted here. Ms. Bent is advocating for the members of our society that are at a vulnerable time in their lives. And the fact is, whether we consider the Dua incident or not, as my co-counsel said, there is concrete evidence that Dr. Platnick did commit misconduct. And someone on the receiving end of the victim payout could suffer. As a doctor, Howard Pladnick has a higher ethical duty to report on any patient that is subject to his professional opinion, and he swore an oath to do no harm. Yet lowering the amount of money that a patient receives after a potentially life-shattering accident does harm. And what's undisputed is the evidence of Dr. Pladnick's misconduct in the Carpenter matter.
Counsel, did your client go to the college to complain about this?
No, Your Honor. Our client, she proceeded to make her expression based on the evidence she had. She had testimony from a doctor that was involved in the Carpenter matter. And as a lawyer, she would understand the testimony. There's obviously there's a definite appeal to the truth, obviously, with testimony. This doctor he swore that there was misconduct here, and she had concrete evidence of such misconduct.
So why not take that concrete evidence to the college if she's so concerned about what is happening here?
That was part of her expression. She outlined this incident, and she made her claim to the organization in the listserv server, which were other lawyers that dealt with similar matters and worked in the same field, essentially. And so she did link the two statements, the Dua matter as well. But what we have to recognize here is the nature of her statement. There is truth to it because of her evidence from the Carpenter matter. Now, I want to take us to points protection, where the Supreme Court highlights that in conducting a Section 137.14b analysis, one must consider the potential for a chilling effect on future expression. Lawyers could be scared to speak out on these issues of public interest for fear of retribution in the form of these expensive and time-consuming lawsuits. And there's also potential to limit public debate and political discourse in the wider society as well, not just lawyers, but anybody in society that is related to this.
But Mr. Muller, you're speaking to the fact that this is anti-SLAPP legislation. But here we're talking about a potentially defamatory set of statements against a professional individual. Nothing could be more important to that professional individual than his reputation. Is that the kind of situation that you think this legislation was really intended to stop?
I believe that this legislation was created to be investigated on a case-by-case basis. And in this case, the important facts that we need to look at are that although Howard Pladnick is a professional with a professional reputation to maintain, he damaged his own reputation by committing the misconduct in the Carpenter matter. And when we take a look at the weighing exercise and the balance of public interest, when there was actual misconduct that the public arguably needs to be aware of, when Ms. Bent took this expression to a limited server of lawyers, she was looking out for the interest of the public, which in our weighing exercise proves the exceeding of the balance to the favor of Ms. Bent. And I also want to emphasize that in passing this section of the Courts of Justice Act, legislature recognized the public benefit of protecting free speech, even if it comes at the cost of some people having their day in court. So if the benefits of protecting Ms. Bent's speech outweigh avenging Dr. Pladnick's reputation, his lawsuit must still be dismissed. And even if his claim does technically have merit, for the reasons we outlined regarding the importance of her expression, the protection of her speech outweighs the importance of his proceeding.
Thank you, Mr. Muller.
To conclude, may I conclude, Your Honor?
Time has elapsed, Mr. Muller.
Okay, Your Honor, may I have a 30-second indulgence just to wrap up my final submission?
Proceed.
Thank you, Your Honor. To conclude, my co-counsel and I have made 4 primary submissions today. My co-counsel has mentioned our submission regarding the defense of qualified privilege, and you then heard my submission that Ms. Bent was not only assisting with the administration of justice, but also not responsible for the republication or leak that occurred after she made her expression. You heard our submissions referencing the motivation behind her expression and its importance, as she is advocating for a vulnerable section of the population in a highly privatized and profit-driven industry. Upon hearing these submissions, we respectfully ask that you dismiss the defamation suit filed by Dr. Pladnick based on the legislation of Section 137.1 of the Courts of Justice Act. Thank you.
Thank you very much. Now the respondents, who will proceed first?
Honorable Justice, it's going to be me, Jeffrey Zhang, proceeding first for the respondent side.
Very good. Indeed,
Okay, I would just like to clarify first, as this is a change of format, but is every attorney granted 10 minutes for submissions?
I believe it was
what I
7.
heard.
I was told 7.
Okay, but I think the appellant
I
side,
think the appellants were great. Apparently, the appellants were given about 10 minutes. So I'll take it upon myself to say that you should be allowed the same amount of time.
okay, thank you, Justice Rothstein. All right, let me just set up a timer. Good evening, Justices of the Court. My name is Jeffrey Zhang, and along with my partner Abel-Dres, we appear before you on behalf of the respondent of this case, Dr. Howard Platnick. Now, the issue before this court has been summarized to a great extent by our friends, so we will kind of gloss over this with relative speed. In the first step of section 137.1, the appellant needs to prove that the matter is relevant to public interest. And in step two, and in step 2, we must prove substantial merit and the invalidity of the moving party's defenses. And finally, step 3, we must prove that a weighing of public expression and harm to reputation weighs in our favor. For the reasons that follow, I ask your honors to dismiss the appeal and allow Dr. Platnick's day in court. First off, we would like to say that we concede step 1, as the communication was pertinent to public interest. However, we submit that Dr. Platnick clears both the step 2 hurdle and the step 3 hurdle. Today, I will be discussing step 2 and my partner step 3. Let's start with step 2.
Counsel, do you need to just accept, do we need to accept that there is one, or do we need to accept all 3 in order for this to be granted?
Sorry, Justice Davidson, what are you specifically referring to? Sorry.
How many elements of the test must be passed in order for us to find in your favor?
Well, Your Honor, we must prove that the defamation claim in step 2 has substantial merit and that Ms. Bent has no valid defense against it. And in step 3, we must also prove that the weighing of public interest rules in our favor. So we must prove both step 2 and step 3.
Thank you, counsel.
Well, Mr. Zhang, aren't you setting a bar even higher than the legislation does? It just says that you have to have grounds to believe, isn't it?
Yes, that is true, Justice Rothstein. We have to prove that a grounds to believe rules in our favor.
So you don't have to prove.
Yes, there must be a grounds to believe that it is in our favor, Your Honor.
Go ahead.
Now, the first issue is valid defense. Again, we must show that Ms. Bent has no valid defense to Dr. Platnick's defamation proceeding. Now, the appellants have put into play the defense of qualified privilege. However, qualified privilege can be defeated in 2 situations: when the dominant motive was malice or where the scope of the privilege was exceeded. Now, it is important to know that one of these is enough to defeat qualified privilege. Subsequently, we submit that Ms. Bent's privilege exceeds the scope of qualified privilege and will not be contending malice, contrary to what our friends have anticipated. Now, in their submissions, our friends have submitted that Bent's statements fall within the scope of qualified privilege, as Bent's conduct was relevant. Now, Justice Ha-Redeye asked a question to them regarding the application of a standard of reasonable and appropriate, and our friends have suggested that a standard of relevance would be adequate in this case. We would like to respectively disagree and submit that a standard of reasonable appropriateness should be maintained and that the ruling of Hill v. Church of Scientology must be upheld. A standard of only relevance would expand the scope of qualified privilege beyond what is rational. Let us illustrate this with an example. Say an aviation expert is conducting privileged communication with a large group of, say, 500 pilots. In the process, the expert references a specific accident and claims a particular pilot is responsible when that is not the case. Would the reference to the specific accident be relevant? Yes, of course. But we can agree that such speech would not be the type of speech protected by qualified privilege. Such speech is unprofessional and not within the scope as outlined in Hill v. Church of Scientology. Hence, we ask that the court uphold the ruling of Hill, which was the standard of reasonable and appropriate. Now, to explore the defined scope of privilege, Hill indicates that the information communicated must be reasonably appropriate in the context of the circumstances existing on the occasion. And this indicates that we must consider two factors: the purpose of Bent's communication and the nature of Bent's statements. Let's start by first discussing the purpose. Our friend submitted earlier that Bent's communication was reasonable because she had a duty to inform the members of the OTLA about specific examples of misconduct and to, quote, improve the administration of justice. Respectfully, justices, our friends have misconstrued the purpose of Bent's email. The email was meant not to inform the list of attorneys of specific cases of misconduct, but rather to check their own medical records for any discrepancies. The fact of the matter is that Bent urged the attorneys to, quote, always get the assessor's files. This was a clear and personally stated duty and is only limited to this. Given this intention—
Why is that personal? She's telling these lawyers to take care in the kind of discovery that they're looking for. Well, isn't that something important for the profession?
Honorable Justice, that is correct. That is her intention. However, we must be careful to only stay in the limits of her stated intention, which was to encourage her lawyers to always get the assessor's files and to check them themselves for any discrepancies, and not to personally and specifically single out a single expert and a specific incident. Given this intention, it was unreasonable and inappropriate for Bent to make serious material allegations against Dr. Platnick. These allegations added very little value to Bent's communications and instead made serious allegations against Dr. Platnick's conduct and very character. Now, Justice Rothstein has also asked whether or not a more general warning would have been more appropriate, and if not mentioning Platnick's name would have made sure that the comments were not defamatory. And we agree with these concerns. Bent had an array of reasonable options that she could have brought up. For example, if she wanted to emphasize her point, she could have stated that she was aware of specific cases, not naming Platnick by name, or she could have simply urged the attorneys to be extra careful. In either way, honorable justices, she has obviously exceeded a reasonable context by sending such a defamatory and libellous statement. Now, we must also understand the nature of the communication and the circumstances leading up to it. In Hill, we find a similar case of a lawyer not having done enough fact-checking before sending out statements. Hill found that the attorney's statements were not protected by qualified privilege on that basis. Similarly, in this case, Ms. Bent did no fact-checking, no consulting, and took no investigative steps, zero, before posting severe allegations of misconduct against Dr. Platnick, against his professionalism, character, and reputation. Instead,
counsel, what would you say to the argument of your friends if there is some truth to the statements, at least as it relates to the Carpenter affair?
Well, Your Honor, even if one of the truths in the statements is proven, that is not enough to prove justification. And while I know we are not contending justification, we are submitting that even if one of the statements were true, this does not gloss over the fact that Bent did absolutely no preparation before sending this email, which is what this argument is about. It is not about whether a partial part of the statements were true, because that is simply not relevant to disproving our argument. Instead of fact-checking, instead of meeting with Dr. Platnick, she relied on a 3-year-old memory. Now, our friends have brought up the confidentiality clause as a defense for lower due diligence. However, Ms. Bent has broken the very same agreement by sending a profusely defamatory statement, as your honors have stated. And when a leader and a power figure does so, it sets a very dangerous precedent. Furthermore, this industry is a rumor mill, and in the time of social media, the widespread availability of information in our world, and with such a serious allegation made, this substantially weakens their very argument. As we see, Ms. Bent, even as a veteran lawyer with decades upon decades of extensive experience, as Justice Davidson has pointed out, she has chosen not to do any work at all, none whatsoever to corroborate her findings. Her statements were unreasonable and inappropriate given her duty, and while the statements themselves were also unreasonable by nature, in accordance to the Hill v. Church of Scientology. Therefore, justices, her statements fall outside the scope of qualified privilege, and the very defense must not hold. Based on the aforementioned, I submit that, again, Ms. Bent's defenses are invalid, as she has exceeded her scope of qualified privilege, and thus Dr. Platnick's claim must proceed. Barring any questions, I will now transfer to my partner, Abel, who will conduct a weighing of the public policy considerations.
Thank you, Mr. Zhang. Mr. Dires.
Good evening, Justices of the Court. My name is Abel Dress, and I will be representing the respondent, Mr. Platnick. I will be concluding the submissions begun by my co-counsel, Jeffrey Zhang. Specifically, I will be going over step 3 of the SLAP clause and its public policy argument. In this step, we, the respondents, must prove that the public interest in proceeding with Mr. Platnick's claim outweighs the public interest in protecting Ms. Bent's expression. To prove this, we intend to make 3 primary submissions. 1, Mr. Platnick suffered significant harm in the form of monetary, reputational, and personal damages. 2, Ms. Bent was liable for such damage. And finally, 3, the public interest in proceeding with the defamation claim outweighs the public interest in protecting Ms. Bent's email. Let's start by first assessing the harm Mr. Platnick has suffered. Shortly after Ms. Bent's expression, Mr. Platnick had a short-term impact to his business of just under $580,000. This was derived from a drop in booking appointments he received, dropping from 100 a month to a measly 11 appointments in January 2015. Further, his business partners, mainly insurance companies, had placed him on a blacklist, which resulted in significant loss of business in both the short term and the long term. In his 20 stellar years of practice, Mr. Platnick has never endured such a greater loss to his professional career. This is a person who has worked decades to reach a high degree of professional success in this industry. All his works and all his meaningful contributions have been swept under the rug due to this single expression.
But do you concede that there's a problem in the Carpenter case, at least insofar as the record is concerned for purposes of the motion?
Excellent question, Honorable Justice. We do concede that there is an issue in that case. However, we will, as I will explain later, Ms. Bent's email and the public interest regarding proceeding with the defamation claim is directly correlated to this reputational damage that Mr. Platnick had endured.
But
Now,
if indeed there's some basis for the Carpenter problem, isn't he the author of his own misfortune?
May you repeat the question?
If there is truth to the Carpenter problem, Carpenter issue, isn't he the author of his own misfortune? I mean, you're saying that he suffered this dramatic loss of business, which apparently is true, but isn't that because he made a mistake and did something unprofessional in the Carpenter case?
Yes, Your Honor. He did conduct something unprofessional in that the Carpenter case. However, we submit that due to the expression of Ms. Bent's email and the nature of the expression, that Mr. Platnick should not have been held liable for all his work to be invalidated due to this one expression, which, as mentioned, as I will mention later, has its own faults in terms of the nature of its release. Now, along with financial damages, Mr. Platnick had also suffered significant reputational losses in the insurance industry. Its importance is what a reputation is widely accepted, with points protection stating that, quote, reputation is one of the most valuable assets a person or a business can possess. Now, Justices, I would like to direct your attention to my second point, Ms. Bent's liability for such harm. In order to remind the court, Determining a causation of the expression and harm is not necessary. Rather, as stated in points protection, the respondents must provide evidence, quote, to draw an inference of likelihood in respect of the existence of the harm and the relevant causal link. Ms. Bent originally communicated the email in the OTLA listserv group containing 600 lawyers representing victims in motor vehicle accidents. Now, part of the harm suffered by Mr. Platnick was sustained after the leak of the email. Now, liability for reproduction can be claimed if, quote, the publication was foreseen or reasonably foreseeable by the defendant. Now, with the insurance industry having an active rumor mill and Ms. Bent being the president-elect of OTLA, it would be very reasonable to assume that one of the 670 lawyers would leak this email, an email that had significant consequences in terms of Mr. Platnick's reputation.
So counsel, I'm going to rephrase that then. Is it reasonably foreseeable that lawyers would breach a confidentiality agreement that they've signed on to?
Yes, Your Honor. Considering the severity and the potential implications of leaking an email, such as the email that Ms. Bent shared to the listserv group, we submit that one of the 670 members, a large amount of lawyers who knew and were experienced in an industry known to have an active rumor mill, we submit that Ms. Bent could have foreseen the republication of the email. Now, further, we submit that the harm suffered, there was significant harm suffered between the 49 days in which the email was sent and its reproduction in the Insurance Rep magazine. Several weeks prior to the publication of the email, the blacklisting process had in fact already begun. Direct financial damages can be seen in Mr. Platnick's booked appointments. In December 2014, Mr. Platnick's bookings dropped from an average 100 bookings a month to 35. However, the publication of the email was on December 29th, 2014, the third last day of the month. Thus, it could be...
Is Dr. Platnick employed by a multidisciplinary assessment center?
No, Your Honor. According to the case, Mr. Platnick engages in business relationships with the insurance companies themselves.
Was he not engaged by a company called Sibley?
Yes, Your Honor, he was. However, his own financial damages and the drop in bookings shows a significant isolation to his damage to his reputation alone.
And is it possible that he didn't get bookings because the company that books him didn't book him in for other multidisciplinary assessments after this situation? And it's not the insurance companies at all, but perhaps the organization that organizes these catastrophic impairment assessments?
Yes, Your Honor. We submit respectfully that most likely is not the case, as Mr. Platnick's, once again, Mr. Platnick's bookings dropped from 100 to 35, and due to Ms. Bent's expression to that email, the drop in bookings had occurred. And furthermore, Ms. Bent's expression directly referenced Mr. Platnick. And as Ms. Bent's email concerned a group of several lawyers, we assume that that the OTLA's group and the members within it communicated to other insurance companies regarding the information on Mr. Platnick.
You assume, or you have evidence of?
We are submitting that under the assumption that Mr. Platnick was one significantly isolated and pointed out in that argument. Now, finally, I would like to introduce the public interest in proceeding with Mr. Platnick's claim and the little public interest in protecting Ms. Bent's expression. As I mentioned earlier, Mr. Platnick had suffered significant reputational losses. This reputational damage is directly connected with the public interest in proceeding with the defamation claim due to the fundamental importance of protecting reputation, which are fundamental to maintaining a democratic society.
But why is that public interest? That's his private interest.
Excellent question, Your Honor. We submit that if Mr. Platnick is not able to conduct his business with the fear of being potentially with information potentially falsified being spread about him, Mr. Platnick cannot be able to conduct a basic business, and thus his case could potentially connect to others. Now, I ask, my time is about to elapse. However, I ask for a brief indulgence to answer your question and conclude my statements.
Proceed to answer the question.
Now, Your Honor, if we expand this case to a public interest, if Mr. Platnick's fundamental right to protect his reputation and his ability to conduct business with a solid reputation is undermined, this could set a dangerous precedent in allowing defamatory speech to continue without any safeguard against it. Now, we would like to reiterate the importance of freedom of expression. We recognize that freedom of speech is a bedrock of this democracy. However, this democracy, once again, does not protect defamatory speech. Similar to that of hate speech, the defamatory speech works against the fundamentals Section 2 of the Canadian Charters of Rights and Freedoms attempts to protect, thus allowing Mr. Platnick's claim to be dismissed as a... Yes, Your Honor.
Thank you very much, Mr. Durres.
Okay.
Thank you. What is the procedure now?
Yes, so I think if that concludes the submissions, we will be placing all the justices into a separate breakout room so that deliberations may begin. In the meantime, everyone who is still around, please stick around a little bit longer. Once the justices are complete in their deliberations, we will move them back into the main room where we will be announcing the results of the round. So if everyone could just wait one moment here while we assign the justices. Okay. And I think the breakout rooms are open, and we will also be placing the competitors into their own separate breakout rooms. That way, they get a little bit of privacy and a chance to relax a little away from the public eye. So to that end, if the competitors could, so Jacob and Helen, along with Jeffrey and Abel, I think we have the rooms all set up. So we'll get it open up now. Yeah. And as for everyone else, really happy you could make it out to watch the final rounds live. Please stick around for the judges' comments and final deliberations. For those of you who have not done so already, please give us a follow on either Instagram or LinkedIn. We're going to be posting a lot more content, highlights from this weekend throughout different social medias as the next couple of days goes on. So please stick around for a few minutes and we will be resuming shortly. Hello, everybody. So I think we are back now. If everyone could please sit tight for just a few moments more. The breakout rooms are closing down and the judges will be in shortly. I think some of them are just freshening up a little bit before they enter the courtroom. And if the finalists please turn their cameras on. Yeah, perfect. Look awesome. Okay. So I believe the breakout rooms are closed down. So Justice Davidson, Justice Adams, Justice Ha-Redeye, and Justice Brown, along with Justice Rothstein, are back. Without any further ado, we will get into the judges' comments as well as the final decision. Justice Rothstein.
Thank you very much, John. Well, this was just an exceptional treat. I know that I speak for all of us when I say that you really were, both sides, most impressive. You really did well. You did as professionally as I know I have seen many lawyers do, and we're extremely impressed. And as between the two teams, it is very, very close. With saying that, I'm going to turn over to Justice Davidson, to Jen, and ask her for some comments.
Thank you, Justice Rothstein. I have comments for each of you, but first I just wanted to say with all four of you, you all have a very strong career ahead if you choose to pursue law. You have done an excellent job and really put together something that amazes me when it comes to the timeline you have to put this together and your age. It really did come across beautifully professional. I've got comments for each of you. So first of all, Helen, hi. You have a great voice. You're very strong and confident. You came through with unwavering certainty. And you were able to really focus in on what you needed to do and not let somebody throw you off, which I think takes a lot. It's rather easy to fall down a rabbit hole, and I was very impressed that you weren't going to do it. Watch going above and beyond thresholds. It's a really delicate line, and it's not one that you really need to know that much detail right now. But when there's a line that you need to pass, stick there. Don't try and overachieve, because you had such a strong argumentative style that I think you did a great job. Mr. Mueller, I thought you did a great job too. You also have a very professional appearance. You come across very, very powerfully, and you are you knew your case law, you knew your argument, and you were very, very on track the entire way through. Watch things like motivation. They're a little bit challenging to deal with, and they're not necessarily something you had to deal with in such a great depth. Mr. Zhang, I thought you also did very well. You were very well spoken. You have a very comfortable sense about you, that you were comfortable throughout. You were comfortable speaking to us. You were comfortable answering questions. Watch your speed a little bit. Try and keep your pace to a level that people are well able to understand. You go almost a little bit too slow just to keep yourself going. I thought you did wonderfully though. And Mr. Dress, I really did like your public interest arguments. Keep an eye on where you're going with what's public interest and what's private interest. But I thought you had a very good delivery. You were well-spoken, you were persuasive, and you did a good job at answering questions. I believe I'm passing this off to,
Yeah.
I'm sorry. Oh, yes, Justice Adams. I give the floor to you.
Thank you very much. I would echo those comments and go further, maybe to encourage you to consider careers in law. I think y'all did very, very well. It's very impressive. I'm going to keep my comments fairly general. You're all very, very poised. And I was also impressed with your speed. It's so difficult to speak slowly and to stay on point, but it's very, very important. And you all did that very, very well. I was impressed with the way that you dealt with questions. Nobody got flustered, and there were some tough questions. You respectfully disagreed when you had to. And again, that's a very important skill to develop. But I'd make the one comment that everyone at some point made a generalization or you assumed something, and it's just you just can't do that. So try to stick to the facts that you've got, the evidence that you've got. You live and die on the facts. So if you don't have the facts, don't assume something, because it never goes over well. There was a moment when I think one of the justices suggested that judicial notice was being requested, and that's one way around not having the facts. But again, you really want to try and stick with the facts as much as you can. But overall, I was super impressed with both sides, and congratulations to everyone.
Omar.
So I'm not going to reiterate what I've already heard, but I will again applaud all of you, especially at this point in your educational careers, and in engaging in this type of advocacy. I know many of us here wish and dream that there was something comparable when we were in high school. Like, this is just amazing that you're doing something like this, but also the performance. And we're not just saying this to make you feel better or feel good, is really impressive for students at the stage at which you're at. And so please do continue to explore the law further. My hope is that there's something in this case that is perhaps cause some interest for you to look into it further as a potential career, and I'm sure it'll serve you well. A couple points that I will mention, and I'm going to provide more general type of feedback. I think that it is often a tougher challenge for appellants who are dealing with the Supreme Court of Canada decision to formulate an argument. So I think that is a recognizable challenge. And I think that at the same time, the appellants did quite well in anticipating or trying to anticipate what the respondents' arguments would be. Of course, the respondents, and I think this was done quite well, actually did respond to the arguments that they heard. You'd be surprised how many lawyers don't even do that. Okay, so you did modify your submissions, and you actually did respond to the submissions that you heard. And I think that's a very, very effective way of advocacy, of engaging in advocacy. And more importantly, it shows that you're paying attention and you're not strictly reading off a script. And so I think that's what mock trials and moots are all about. And so kudos to you all. And I think I'll pass it on to Justice Brown.
Thank you very much. Well, I echo the comments of my three predecessor justices. You all did a great job. It was a pleasure listening to this moot. Very enjoyable, very entertaining, as courtroom stuff should be to a certain degree. I'm going to have two general comments. The first is I was very impressed with the ability of all four of you to recognize the importance of answering the questions posed by members of the panel immediately and directly. It's often not easy to think on your feet within the course of 2 or 3 seconds to come up with a question, which when you hear it, you think, my heavens, is this from left field, or I haven't thought about this before. But at the appellate level, the ability to answer questions posed by the judges and to engage and use that as a means to get into a dialogue with the judges on an issue that obviously of some interest to them is just critical. And you all recognize that. And I was impressed with your ability to attempt to provide answers to the questions. The second comment I have is one which is more with respect to the tone of submissions. And you're in high school, so you, to a certain degree, if I can put it this way, don't know any better. This is more a debate than it is an actual exercise of advocacy within a courtroom. But I think you'll discover, if indeed you do embark upon a legal career and you get into the courtroom, there are different tones that are appropriate to the trial level, where you're really trying to create the record. You've got raw evidence and you're trying to get findings of fact. And I would say there's perhaps a greater element of passion and to a certain degree rhetoric that is permissible at the trial level. By the time you get to the appeal level, the record is created. Findings of fact have been made, although this was a motion, so it's a bit different. But at the appeal level, you are in an environment where the expectation is that the submissions will be a bit more analytical, measured, and dispassionate. Not that you are just sort of zombies and you aren't exuding passion on the part of your clients. Of course you are, but it's a different kind of tone than in the trial level. So actually one of the comments I made to my fellow judges when we were off is that the level of rhetoric here, I think, was appropriate for a debate. But I don't think some of the rhetoric was appropriate for an appellate court. But that's just something that you are going to have to learn through experience as the years go by. That having been said, it was a delight listening to the submissions of all four of you, and I echo the comments of my colleagues. If you do have a legal career or an advocacy career on the horizon, I would certainly commend you in pursuing that. You all have the raw material that I think would result in very solid counsel at the end of the day. So thanks for your presentation. It was a delight listening to you.
Thanks, David. I'll make a very few comments because the comments that have preceded me really have taken up anything that I had really intended to say. I'll just make a very few comments. Helen, there was one thing that you did that I did want to point out. You picked me up when I got confused on subsection 4 of section 137.1 about who the onus was and where the negative and where the positive was. And it was me that was wrong. And you quite rightly asked me to repeat again. And I think I repeated it wrongly again. But whatever, that's exactly what you have to do. You know, judges make mistakes. And if you, in general, but if you're in court and you're arguing a case and the judge says something or asks you a question that doesn't seem right, you've got to come back and you've got to ask them to explain further. Or perhaps you say to them, do you mean this or do you mean that? But you've got to get the question very clear. As Justice Brown said, you all answered questions directly, but I did want to point that out. That's really a good way to deal with a question that's kind of, as he put it, out of left field. Jacob, you knew the law cold. It was a pleasure to hear that. On this question, I think Jeff mentioned about assumptions and facts. Very, very important to stay with the facts. I mean, you're in an appeal court, you're stuck with the facts from the record, and that's what you got to stay with. Jeff, I was really impressed with your recounting from Church of Scientology, the template for the scope of qualified privilege. It kind of gave a lot of form to the argument and was grounded in authority, and it was very strong. And Abel, you very good answers to questions. One thing I would say, I think you said to me on one or two occasions, and I think a couple of others of you may have said the same thing. When a question was asked, you said, oh, that's a good question. That's probably not such a good thing to say to a judge, because it betrays that maybe the question is really good and it's going to be a hard one for you to answer. So probably not such a guy. I mean, I'm complimented because you told me how smart I was with my question, but in fact, probably not the best way to respond to a question. Overall, it brings us to the end, and it brings us to the conclusion of this moot. You were all excellent in what you did. I can tell you that I don't mind telling you the panel was split on the result. In the result, with a split decision, the panel is of the view that the appellants are the winners of this final moot. But we want to assure the respondents that you came very, very, very close. Thank you very much for excellent work.
Thank you so much, Justice Rothstein, for delivering the final decision of the Dominion Court of Last Resort. And thank you to all of our judges for the time that they have taken out of their evenings to come out and support the future of the profession. Needless to say, everyone who competed in this final round would make an absolutely amazing lawyer at some point in the future. And I would urge all four of you to potentially consider joining, in my humble opinion, and those at the court, I'm sure, one of the noblest professions out there. So to that end, justices, if you do have to run, I understand it's getting a little bit late. We're just about wrapping up the event. There's a few more final words we would like to share on behalf of the organization. And then from that point on, we will be calling this year's 2022 Varsity Cup to an end.
Are you releasing us now, John?
Yes, Your Honor, yeah.
Thank you very much.
Do you want to take a picture or?
Absolutely, yes. Did someone, I think Justice Brown might have dipped off. It's okay, we can get him spliced in after we have the recording. So Thomas, I see that you're in the chat with us right now.
Yes, I am.
Okay, Thomas, would you mind doing the honors? So first and foremost, if the judges and the finalists could just have their cameras on and give a nice big smile for the camera. And Thomas, if you could give us a nice screenshot.
Yeah, for sure.
Lovely.
Give us.
All frozen.
Sorry, John, if you could give me a moment, I could actually co-spotlight all the judges and competitors. Do you want me to do that?
Yeah, okay, you're a bit more tech savvy than I am, as are most of the participants in this event. So yeah, if you would like, yeah, that'd be great.
All right, one moment while I set that up.
Sure. Yeah, okay. I think this will make for a little bit of a higher definition picture.
Yep. Just trying to go through all the justices here.
Yeah, and it's okay. We can splice Justice Brown in after. Beauty of modern technology.
Okay, just to check, I think we're just missing a few justices right now.
I think we're missing Omar.
Omar is in this.
There.
Oh, there he is. Okay, excellent. Okay, excellent. I think that's perfect. So, yeah, if everyone could give one quick final smile.
Is it done? Is the picture done?
Yeah, it is, Your Honor.
Okay. Thank you very much. Good
Thank
luck.
you.
Congratulations to both teams. Really, you did a fabulous job.
Yeah.
Thank you very much, Your Honors.
Yeah.
Thank you.
Congratulations.
Thank you.
And then if we could do one more quick picture with everyone who is here today on the call, we'll set it as gallery view. So if everyone who is spectating today could turn on their cameras, it would be great to get a nice group photo with everyone. Sure, people? Okay, great. Excellent. Sweet. So yeah, one more picture and I think we're okay. Yeah. Quick smile for the camera. Okay, beautiful. Awesome. So yeah, I just wanted to say, I don't want to keep you around for much longer. It is getting late for many of you here, especially those on the east end of the country. But thank you all again so much for participating in this year's Varsity Cup. This is our second year of running this competition, and honestly, I'm honored that so many of you took time to engage with this event, to show up, to spend your very busy days working on this very challenging problem in order to present your arguments before, all these judges over the course of the last couple of days. I haven't had the chance to see everyone perform, but I was making the rounds, and honestly, the caliber of competition was very, very high this year. For anyone who might be interested in continuing to be involved in terms of the mooting community in the country, I would really urge you to potentially reach out to Dominion. We're always looking for more volunteers and people who might be interested in helping to build out this small but growing community of individuals who are passionate about the law, passionate about social policy, passionate about increasing access to education, and passionate about knocking down barriers so that more and more individuals from all walks of life can experience the joy of legal advocacy and benefit from the immense amount of knowledge that is present and available to be accessed. And for those of you who are graduating, I did want to wish you congratulations on completing high school. I know many of you are in that situation. And I want to say, well, it might feel like a little bit of an end, and this may be your final varsity cup. It is not the end for you in terms of mooting, if that's something you're interested in. Truth be told, the undergraduate competitive circuit is much more rigorous and much more well-developed than the high school circuit. So for those of you who are graduating, I would highly encourage you to get involved with your pre-law society, get involved with the mooting society, get involved with Dominion, and keep it going. Because at the end of the day, the issues that we're discussing here, it's not just a mere academic exercise. We are dealing with real world issues, and it will take all of us working together in order to come to the solutions for these highly complex issues. So to that end, thank you all again so much for your participation in the 2022 Varsity Cup. And I look forward to seeing all of you, hopefully, again.
Thank you.
Bye,
Thank you,
everybody.
John. Thank you, guys. You did a very good job. Have a great night.